interdict vessels transporting and smuggling people from Haiti to the United States and return them to Haiti immediately without worrying about the refugees or not. And that's what they said there. And they said neither the immigration and naturalization statutes nor the conventions on the status of refugees limit the president's power to repatriate undocumented aliens. So there's already some precedent that if you catch people early, you could send them back. But that's why the Supreme Court even have subject matter jurisdiction. Of course they do. But that's just so you guys understand what they're looking at here. Clarence Thomas is, I think he's hoping the guy says international law. Fuck that. But he's just pointing out that, even if we're following international law, it doesn't matter. And joining us is Uncivil Law. Hey, Kurt, how you doing?
I'm doing great. How are you, Sean?
I'm doing all right. Did you, so you haven't heard anything of this yet?
No, not really. I saw like one clip excerpt, and that's about it. So I'm excited.
Okay. All right. Well, let's get to it then.
The first is, as this court held in Sale, those provisions simply don't apply extraterritorially. They apply to the return of someone from the United States, not to, in Sale, the return of Haitian refugees who were interdicted in international waters. And secondly, even where that convention does apply, what it prohibits is returning someone to a foreign country. Metering doesn't return anyone to Haiti or Guatemala or wherever the person might be coming from. It just says you can't set foot in the United States.
I'm not sure that I understand how you can say that we're not violating our treaty obligations with your reading, and why Sale, you think Sale protects you. Sale very clearly says that U.S. asylum and withholding protections apply to those who reside in or have arrived at the border of the United States. It also explained that refoulement means a defensive act of resistance or exclusion at the border, not merely returning a person to a country. Now, the Refugee Act was passed in response to the MS St. Louis situation, which was a ship in 1939 carrying over 900 Jewish refugees.
Oh no, this is like a Reddit argument of, oh no's, Holocaust. Like, really, is this where we have to dig back into the stack to make this happen? We're all the way back to, but in Holocaust, I just, come on now.
Yeah, I mean, just waiting for some solid legal arguments.
Yeah.
That landed in Cuba. The refugees weren't permitted to unload themselves. It then came to the coast of Florida, and the U.S. wouldn't let it dock at all, and turned it back. And it did the same in Canada. Canada wouldn't let it dock. Mm-hmm. So the Refugee Act was passed to ensure
those evil
that
Canadians,
people who arrived at a border and knocked on the door, because that's what you're saying. These are people who come to the line. There's an agent standing at the line that's open to everybody else except refugees, correct? They're letting in workers with permits to come into work. They're letting everybody else in, but they're not permitting the people who come to the line, to the door, and knock on it, who want to claim refugee status. You're saying, we're not going to inspect you. How does that not violate the Refugee Treaty Act or the spirit of the St. Louis UN Convention?
To start with the statute doesn't say arrive at the door.
No, but it says arriving in the U.S. in various provisions. The inspection provisions says all aliens who are applicants for admission or otherwise seeking admission or readmission or transit to the U.S. shall be inspected by immigration officers. So various provisions of 1125 also speak about aliens arriving. Someone on a plane arriving to land in LaGuardia may not have put their foot on U.S. land, but they've arrived in the United States. They're arriving. They're knocking on the door.
Again, the statute that is specifically at issue here says arrives in the
So
United States.
if I believe that...
Once again, there's a difference. the plane has made it inside the territorial boundary of the United States. I'm not going to be that persnickety to say, well, until you're actually outside the terminal, you're not actually on our ground. But this one, they're literally outside the U.S. border saying, no, Alto, you are not allowed to enter. There's a significant difference here.
But even in this scenario with it being in the United States, but before it passes customs, for many purposes, that's not treated as being in the United States.
But I think in this situation it would, though, because you're inside. You made it inside the territorial jurisdiction of the United States. Because if I'm applying for asylum, I'm at the port of entry. I haven't cleared customs yet either.
Yeah.
So I think this is a completely ridiculous argument from her. But oh well, let's see what she cooks with.
Your reading violates.
Also, how bad does it suck that you don't get to have your picture up there when you're on the you're telling your mom, I'm gonna be in front of the Supreme Court. His parents log in and it's just no picture. It's got to be embarrassing.
The UN Convention. Then what you're telling me is that Congress, when it passed this language in 1996, intended to reject its treaty obligations.
No, I'm telling you.
Without conversation about it. And a House report that basically said,
are you going to let him answer a question at any point?
Congress, in fact, told us and intended to make that provision. The House report stated that the new version.
Yes, Senator Sotomayor with her filibuster.
Anytime you want to let him answer the question would be fine.
Of 1158 applies, quote, to any alien who is physically present in the United States or at the border of the United States. That was the language of the House report.
Not the language of the statute. The statute says in.
Yeah, she's busy using legislative reports and the legislative history, not the actual. What does the bill say?
Yeah, exactly.
The United
But
States
don't we read statutes in their context?
You read statutes according to their text, and there's no ambiguity.
No, you start with the text and context, correct?
Mr. Suri, the text
You start
has
with the
to make
text for
sense.
context. That's interesting.
And what is a little concerning.
I never heard that before. You start with the text for context. That's, yeah. Pretty sure, no, you don't start with the text for context. Pretty sure you start with the text for text.
I'm sure you can infer all kinds of context out from reading the text. But look, we've got Justice Ketanji Brown Jackson stepping up and just, we're going to prime the pump.
I'm sure it'll be insightful.
We know what's going to happen. We're just going to prime the pump now.
It just don't make no sense.
I love AI. It's so good now.
Concerning to me about your reading of the statute is the practical implications insofar as it.
Yes. Oh my God. If you read this the way that you read it, I won't like it. Yes, that's a practical implication. I understand it concerns you, but is it legal? That's all you need to be worried about.
Suggests that a Congress that was authorizing asylum would be requiring people to break the law in order to obtain it. So imagine a polite asylum seeker who wants to do everything by the book. He approaches the border, but does not cross, precisely because the law says you are not supposed to enter the United States without authority. Why on earth would Congress have intended or meant for his asylum request to be discarded, not taken seriously, not entertained, but someone who manages to enter the United States unlawfully when the law says you're not supposed to do it and requests asylum, gets their application entertained? That doesn't seem to me to make any sense. That if we're trying to think about what arriving in means, surely Congress was contemplating that a person would be.
Yet, a couple weeks ago, she made an argument that was entirely contradictory to this position. So, very interesting she does that now.
Coming to the United States would be doing so with an intent to comply with the law that says you're not supposed to enter, and thereby asking for entry.
There are two reasons for which that makes sense. The first is that we have a separate refugee admission statute, Section 1157, that protects aliens outside the United States. So it makes perfect sense for Congress to say, if you're in the United States, you go to the asylum route, and if you're outside the United States, you go to the refugee.
Yes, but I'm trying to understand the rationality of your interpretation of arriving in. You were suggesting that arriving in means the person who is literally standing on the U.S. side of the border, as opposed to the person who approaches the U.S. side of the border. And I don't understand why Congress would make that distinction.
The second reason that Congress would have made that distinction, apart from the fact that the person in Mexico already has this other statute, the refugee statute that he could turn to, is that the problem of the world's refugees is not solely the United States' burden to bear.
God.
It's a shared responsibility of nations throughout the world.
What's that, Kurt?
I was just saying, like, thank God for making that point. It's like, how did this become the United States' problem exclusively?
Mm-hmm.
That's a good question.
And the weird part is this case started from Haitian refugees showing up at the San Ysidro border checkpoint. Like, how the fuck are they getting here? How is this our problem? Isn't that a little weird how that works out?
There's a country right next door.
There's a country they landed in to get here. It's called Mexico.
Yeah. Why don't they just cross the DR border?
Yeah. Well, because they don't let them in. There's a whole, then that's a whole nother discussion of, what do they know that we don't?
About the statute at issue, it says arriving in. It first of all distinguishes physically inside, right? And it says arriving in, and it gives those people the ability to ask for asylum. And the way that your reading plays out, a person who is coming to, arriving in, approaching the United States can't make that ask, but they have to somehow violate the law by entering the United States in order to make that ask.
If I complete the answer, Congress could reasonably determine that if a refugee is in Mexico, then the Mexican government is primarily responsible for processing his claim. Once the refugee is in the United States, whether legally or illegally, then the United States has greater responsibility toward.
I guess I don't understand how that's responsive. Can I just finish? I don't understand how that's responsive to my point, which is the person who is arriving in the United States asking for permission to enter is not necessarily, quote, in Mexico in a way that implicates all the concerns that you're talking about. Yeah.
I mean, you're right. You shouldn't get a fucking asylum claim if you come in here illegally. That I agree, Justice Jackson. We agree. And she's going to be like, well, wait, no, I don't know about that. But I agree. If you come in here illegally, no asylum claim. A flare-up is what the answer should be. So that's not what she wants, but that's what she's advocating for. And yes, she is so retarded, and I don't understand it. Don't understand it.
Yes, he is physically standing in Mexico, but imagine a person who has a placard on their body as they approach the border that says, I would like entry. I'm being persecuted in Mexico. Your suggestion that the United States would say, unless you can figure out a way to illegally cross, we're not going to entertain that claim, seems very peculiar.
It seems to me that the premise of the question is that there is something improper about blocking someone from completing the arrival.
The premise of the question is that arriving in has to mean something. And to suggest that it means that you have to actually illegally cross doesn't make sense.
There are other penalties that apply to people who illegally cross. It's a crime to illegally cross into the United States. And the fact that someone has illegally crossed into the United States can be taken into account when the person is making the asylum application.
Precisely.
I'm sorry, please. Counsel, the statutory language, is it arriving in or is it arrives in?
It arrives in.
Okay, thank you.
Mr. Suri, if
Justice Kagan.
I don't think you had much of a chance to answer the part of Justice Sotomayor's question, which I am interested in, about the treaty obligations, and particularly how the treaty obligations should or should not be interpreted in light of the St. Louis incident that gave rise to the treaty.
The treaty was a compromise between the interest in protecting refugees and the interest in protecting national sovereignty. And the compromise that was reached was, we're not going to require nations to admit anyone into the country, but we're going to forbid sending people back to other countries once they have already entered that country. And here, the treaty doesn't apply for two reasons. One, the individuals at issue haven't entered the United States. And two, they're not being sent back to any foreign country. They're just being denied admission to the United States. I would also note that even on any interpretation of the statute, the St. Louis situation wouldn't be covered because there's a parenthetical in the statute that talks about people interdicted in United States or international waters, and they're covered by the statute only if they're brought to the United States. So in the St. Louis example, those individuals were not brought to the United States, and therefore they'd be outside the scope of the statute, I think, even on respondents' reading.
I think Justice Jackson's question got at the fact that your interpretation privileges someone who illegally enters over someone who legally comes close to the border. And why would Congress privilege someone who illegally enters the United States? Can you answer that directly?
I think it's a bit unfair to say that we're privileging people who illegally enter, because people who legally enter are being treated better than people who illegally enter.
I got that distinction. The distinction is between the illegal entrant and the person who lawfully gets very close and wants to follow the rules. That person is disadvantaged as compared on asylum as compared to the person who illegally enters. And the question, as I understood it, is why would Congress do that? So what's the answer?
Two answers to that. The first is we would deny that the person is being privileged, because metering is not saying to the person, the polite asylum seeker, in Justice Jackson's words, you can never enter the United States and your only option is to enter illegally. It's saying our port is at capacity today, try again some other day, and that time when that person comes in, that person could come in legally. The second answer is that Congress could reasonably determine that the United States has greater responsibilities to aliens in the United States than to aliens in Mexico. That's how sovereignty is divided among nations in the world. And whether you got here legally or illegally, Congress could say we have greater responsibilities once you're within our borders.
More generally, or separately, I guess.
I mean, it's a good argument. You know, come back tomorrow. It's the Happy Gilmore argument. Better luck next year. It's like, you just can't do it today. Just can't do it today.
What is the problem? What was the problem that was trying to be solved here when this policy was put in place?
The policy was put in place in 2016 when ports, which might have a capacity of something like 50 or 100 people.
And remember, chat, who was president in 2016? Not Trump. That evil racist Barack Obama.
Holding capacity of 50 to 100 people, were facing lines of aliens far larger than that. And those individuals were demanding entry at that particular time, and ports were overwhelmed. Sometimes they didn't have enough food to feed the people arriving in the United States. Sometimes they didn't have beds in which they could sleep. They didn't have places where they could hold them. So it was necessary for the ports to say, sorry, we're at capacity, try again some other time. And I think respondents' position is that that is categorically illegal in any circumstances, because it always violates the asylum statute and the inspection statute to say we're full right now.
That's not quite what they're saying. It's certainly not what the circuit court said. What the circuit court said was, we have a law that permits the United States to have people reside in Mexico or stay in Mexico while the application is being considered. So there is already that remedy for the government, correct?
There is a contiguous territory return provision, but
Exactly. And what the circuit said is, it's okay for you to say, stay somewhere else while we process this. What you can't do is do what the statute doesn't permit you to do, which is not to inspect me at all. The circuit said you can make a list of people and have a rational basis to tell them to come back in a particular time. But instead, what you were doing was saying, you alien, we're not going to even consider your application. We're not going to take your number. We're not going to do anything. We're just going to turn you back. We're going to be the ship on the MS Lewis and ship you back to be killed wherever you end up. And that's what the statute doesn't permit. Now, you mentioned—
Can I answer that?
Yes.
That's an argument that SAIL was wrongly decided, because that's exactly what the United States was doing in SAIL, shipping people back to Haiti.
No, because the SAIL made very clear that the UN obligation is, if you're a refugee who's arriving at the port of entry, if you're knocking on the door and I'm staring you in the face, you have an obligation to at least listen to my application. And you can tell me to wait. You can put me in a safer place to wait.
Pretty
you
much.
can do a bunch of different things. What you can't do is just turn me back from the border.
And the second answer is, we're not shipping people back to Haiti or whichever country the person might be
No,
coming
you're just
from.
telling them walk back.
No, we're
So
not
they
telling
can,
them anything.
the people on the St. Louis could have swam back. They happened to be on a boat, but that's what we did. They were off the coast of Florida, and we didn't let them dock. We didn't let them dock and take and interview them at all. We didn't consider whether they were being persecuted. And the majority of those people were shipped back or had to go back from where they came and were killed. That's what we're doing here, isn't it?
Like the court in Sale, I do not deny the moral weight of claims made by refugees, but that is not the question before the court. The question
So
before
tell
the,
me,
Would you complete your answer?
the question before the court is what obligations did Congress impose in the asylum and inspection statutes, and those refer only to aliens who arrive in the United States.
May I ask you a question about the statute and about that answer? I totally get that if you just look at the language who arrives in the United States, it sort of suggests, well, you have to be in the United States. So totally get that. It does seem to me that this statute, you don't have to be a superfluity hawk to think that this statute has a massive superfluity argument, problem. Because the way you're understanding that second phrase, the statute ends up saying essentially any alien who was in the United States or who was in the United States. So what led to that kind of superfluity in this statute, and how are we to understand it? It really, if you just sort of, you can't mean that, so in the United States must mean something else.
I agree that the arrives category is a subset of the present category, but there are a few different reasons why Congress might have mentioned that subset the same way it mentions subsets in other statutes that refer, for example, to money or property. One reason is that the arrives category is subject to special rules that other applicants for admission are not subject to. For example, they're automatically subject to expedited removal if they are inadmissible. So when the statute 1225 is talking about the arrives category repeatedly in later provisions, it makes sense to mention them separately in the definitional provision. The second reason is that immigration law has historically drawn a distinction between deportation proceedings for people in the interior of the United States and exclusion proceedings for people who've just arrived in the country. This provision, in this provision, Congress might simply have been trying to make clear that both of those are covered. The third reason is that under the entry fiction, this court had previously interpreted terms that are close synonyms for present in the United States, like found in or within the United States, to exclude recent arrivals. And Congress might have wanted to make clear that it's covering recent arrivals as well. So for all those reasons, the arrives category serves important clarifying function.
It also serves a sort of confusing function. When Congress did this, it must have realized, or you would think it would have realized, that it was just going to confuse matters to essentially say the same thing twice about an alien who was in the United States. I don't think on the entry, what is it called, the entry fiction? I don't think you would have needed this second provision to do that, because you have physically present that should have tipped people off that we're not talking about the entry fiction. And we also have the language about irrespective of the alien status, which also should have tipped people off that we weren't talking about the entry fiction. So if I took that to be your primary argument in the brief, and I don't think it really sort of does it.
Well, if you're positing that there are already two parts of the asylum statute that are meant to address the entry fiction, then it isn't much of a stretch to say that there's a third piece as well. Secondly, the two pieces you've mentioned are not included in—
It's like belt and suspenders and, whatever, a new pair of pants.
And the second point is those two pieces are not in Section 1225. They're only in Section 1158. So if Congress had included the phrase arrives in 1225, but omitted it from 1158, then people might draw a negative inference from the inclusion in one provision and the exclusion in the other.
Can I just ask?
Can I ask you, does the administration, the metering policy has been rescinded. Does the administration intend to reinstate the metering policy if it's successful in this case?
The administration would like to be able to reinstate metering if and when border conditions justify. I cannot predict in advance what border conditions will look like or what specific policy responses the administration would take in response to that.
So, Mr. Suri, why then aren't we just issuing an advisory opinion in this case?
Stabby, you bring up a question here. Why is he not bringing that up? Because it says port of entry in this part of the statute they're talking about. It says port of entry specifically. So. Anything else? Here, what are you thinking so far?
I'm still just trying to parse the actual text of the language and what it does say. And so I'm just trying to understand the issue. And the questioning and the inability to answer is making it difficult to parse the question. They're asking questions screed form, and I can't get him to answer what he thinks the statute means. So it's real hard to have an opinion.
Yeah.
I don't know what to think.
Yeah, I understand. I hear you.
Case. I mean, your back and forth with Justice Sotomayor raised another line of questions that I had along the same lines as what Justice Barrett just indicated. At the time in which the district court in this case issued its opinion, the metering policy had been rescinded. And as you've now represented, the government has no concrete plans to reinstate it. So I don't understand what we are doing other than advising the government in sort of the abstract as to whether or not this kind of thing is lawful. We don't have an actual policy. We don't know who's right as between you and Justice Sotomayor about what metering actually contains because the government doesn't have a policy in effect and hasn't shown us that it wants to have a particular policy. None is on the table. So how do we even have jurisdiction, really, to be addressing this?
It's not a bad question.
The question of mootness turns on whether the court can grant any effectual relief whatsoever to the prevailing party.
And ultimately, the issue is, guys, and I don't know if he's going to address this, there's still basically a class action nationwide injunction on metering at this point, still in effect from the district court. So even if the DHS wanted to do it right now, they wouldn't be allowed to do it. So it's not moot at this point. It's still actually out there. There are still rulings prohibiting them from doing it.
You can grant us effectual relief, and the case isn't moot because there are three types of prospective orders that the district court issued that are still in place against us. The most
Okay, so he's going right to that. Yes, this was still an effective thing right as of right now.
Important of which is a class-wide declaration saying we can never engage in metering at the southern border. If you agree with us, you would lift that declaration, and we'd be able to resume metering. Therefore, the
But
case
you don't have a plan to resume it. I mean, are you suggesting that I'm a little worried about the judiciability in the following sense. At the time the case was initially brought, there was a policy in place, the government was engaging in metering, and obviously we had a live controversy about it. But before the district court issued its opinion, that policy was rescinded. There was no more metering, and yet I think in the record it demonstrates that the parties just sort of said to the district court, well, it would be helpful if you would go ahead and enter your ruling. That's ordinarily not the case, that you don't just have the district court opining on policies that are no longer in effect. So I appreciate that the district court did, and so you would like to get rid of the order, but why wouldn't the right remedy be to just vacate the order rather than having us speak to the merits of it in this way?
If you'd like to look at the issue through the lens of voluntary cessation, you get to the same result. Yes, we voluntarily ceased metering at one point.
There are no findings about voluntary. The district court did not make findings about voluntary cessation, so I don't know how we could go there.
But the test under voluntary cessation is
using as an
absolutely
example
clear that the conduct can't reasonably be expected to recur. And that can't possibly be satisfied here because we're telling you we want to do this policy again if border conditions justify it.
Thank you, counsel. Justice Thomas?
No, it's a valid point. Like, there are different theories where this isn't a problem. And he's like, unlike that, which is like, but that didn't happen. He's like, I know, sweetheart. He's like, I'm trying to tell you, we want to do this again. We want to have the right to do this again.
Well, he was more vague about it. It wasn't like, yes, we'd like to turn on the spigot. It's like maybe someday,
well, no, he said that. Like, we'd like to have this ability
blah, blah, blah. Yeah, so it's a little bit more tenuous.
Well, no, he's like, we want to be able to do it if we like, if it's necessary, we deem it necessary, we want to do it, which means they will determine it's necessary at some point.
I didn't parse it that way.
Oh,
but maybe it's just me.
Oh, okay.
Justice Alito?
During the period when metering was suspended, what would happen in the hypothetical situation or not so hypothetical situation you were talking about where a port was capable of handling, let's say, 50 aliens and instead 300 wanted to enter? What was done?
What was done during the previous administration differed from what was done during the Obama administration. During the previous administration, the aliens were generally paroled into the United States, and the current administration has serious concerns.
They were paroled in the United States and never showed up. So
yeah,
that's a problem.
Yeah.
Concerns about that approach as a policy matter, because that means that individuals whom may not necessarily be entitled to asylum are allowed to enter the United States without showing that they have a valid claim, and it may be years before the person can be found and deported if that is appropriate.
Do you happen to know how many people were paroled?
Lots.
I don't have an exact number on that, but it would not surprise me if it was in the millions.
Lots.
Mr. Sotomayor?
Counsel, the Office of the Inspector General
Millions.
issued a report that said that some of the metering that was not done because of lack of space. It reported on the fact that there were empty beds in at least 2 ports, okay? So Justice Alito assumes the moment in which there were not enough space, but there is a claim that at least one president was using this as a subterfuge for ignoring any inspection whatsoever. Do you have a response to that?
Yes, I have two. The first is that we dispute those facts, and this is at the summary judgment stage, so you can't resolve those disputes in respondents.
But we do have an Office of the Inspector General report that says that, correct?
True. The second answer is that respondents brought 2 different types of challenges to metering in the lower courts. First, a facial challenge saying metering is never okay, even if done for a legitimate reason. That's the only one before you today. And they also brought an arbitrary and capricious challenge saying even if metering is acceptable when the port is actually overcrowded, you can't use it as a subterfuge. That's not before you today.
All right. The language at issue here was passed in 1996. In 1998, the government modified its regulations to define an, quote, arriving alien as an applicant for admission coming or attempting to come into the United States at a port of entry, which is consistent with the policy that had been followed since 1980, I think it is, when the Refugee Act was passed, correct?
Not correct. The courts said in Cardozo-Fonseca, when it was talking about the 1980 Refugee Act, that the asylum statute applies only to aliens in the United States.
But the regulations have always been treating aliens who knock on the door at the port of a legitimate port of entry.
She really loves that knock the door
up until the
analogy.
metering policy.
What's that, Kurt?
It's just like she just really loves that knock the door analogy.
Well, I mean, it really is what it is. You come knock on the door and say, "Let me in, let me in."
I appreciate it, but she keeps mentioning it. It's just a little tiresome.
Yeah, but if you got something good, you keep hammering it.
Knock on someone else's door.
Yeah. No room here.
At least giving them the opportunity to claim asylum, correct?
I'm sorry, that's not correct either. The regulation refers to an applicant for admission, and an applicant for admission.
All right, we're back in the same circle.
Yes.
All right.
Justice Kagan?
I'm going to take you back to the statute, Mr. Surrey, and the superfluity problem. You said to me the second phrase should be viewed as a subset of the first, and I want to understand what you mean by that. What does the first include that the second does not?
It includes individuals who may have arrived in the United States a long time ago, but the process of arrival has been completed. The person would be present in the United States, but the person doesn't arrive in the United States.
Is that really what you're saying? Is that your best? Because it strikes me that that's actually a better argument than the ones you've given so far. That the first phrase is people who have been here for some time, and the second phrase is meant to refer to people who sort of may arrive right now after the statute has gone into effect.
If you're intent on giving these provisions non-superfluous meanings, then we think that's the
well, that's a good thing to be intent on.
Yes,
I mean,
it is
because this is really not like a kind of.
What was that, Kurt?
It's a very good thing to be intent on. Superfluity is strongly disfavored. You want each thing to mean something. So if your proposal is these 2 things mean the same thing, try again. So he's like, if your intent is to read these differently, it's like, yes, Congress probably meant 2 different things. They didn't say the same thing twice.
Yes, they wouldn't say the same thing twice.
Yeah.
Well, they're not that stupid.
Oh, like Congress didn't see that it was doing the same thing in 2 different parts of the statute. I mean, these phrases are like right next to each other, and they must have meant, if you're right about what arrives in mean, I'm looking for a theory as to how that doesn't repeat what the first phrase does.
It's a subset, but that's different from saying that it has a completely different meaning and includes people who don't fit
I got that, but you're essentially saying that the second phrase is a subset that's meant to respond to the fact that they've just put in a provision for expedited removal, which focuses on the same group of arriving people,
Correct.
right? And that the first provision does not really focus on this expedited removal group of arriving people, but instead applies as well, although it also applies to them, and honestly, Congress didn't really need it, but applies as well to people who have been, sitting in Kansas for the last 5 years.
It could refer, for example, to someone who comes here on a visa. The visa expires, but conditions in his home country have changed while he's been in the United States, and so now he.
Is that Kurt?
To say a lot of immigrants sitting in Kansas?
Yeah, well, that's where they all go. It's their Mecca. It's their homeland.
Okay.
Wants to apply for asylum. He isn't in the arrives category, but he is in the present category.
Thank you.
Justice Gorsuch. Justice Kavanaugh.
Is it lawful to impose the metering policy for the government to do that, even if a port is not overwhelmed?
We believe that it is lawful, but we're not asking the court to go that far today. The only issue before the court today is this facial challenge to metering, that it always violates the inspection and asylum statutes. There are separate claims that it would be arbitrary and capricious to engage in metering as a subterfuge, but that's not the issue.
Okay, it wouldn't be a statutory issue, it would be an arbitrary and capricious issue then.
That's the claim that's been raised by the other side.
Okay. And you make an argument, this is a relatively minor point, but it's in your brief, and I didn't agree with it, so I'm going to bring it up, which is page 25. You say that because it's in a parenthetical.
Yes, Kagan clerked for Thurgood Marshall back in the day. She ended up becoming the dean at Harvard Law School. And then she was like the solicitor general for like 90 days. And then they put her on the Supreme Court. So yeah, she really hasn't done, she's done a lot of things, but she, unlike most of her fellow compatriots who have a storied career in the judiciary, she does not. No.
It's different than if it had been separated by commas or dashes. Do you really mean that?
Yes, I
mean, I know we have a case in a particular context that once said that, but I don't know that that's a general rule that parentheses are different than dashes in interpreting statutes.
I recognize that you dissented in the case we're relying on.
Yes. But do you think that's a general proposition, that parentheses are different than dashes or commas in interpreting statutes?
Not that they're different in that sense, but that they convey an aside, and that material in parentheses, or for that matter, even in dashes, don't override unambiguous language outside the parentheses or dashes.
Or commas?
I think commas grammatically.
I just don't want this. I mean, I was surprised to see this, and the Constitution has things in parentheses, and I'm just trying to make sure that this doesn't expand.
The court does not need to rely on that argument.
Thank you.
For us.
Justice Barrett.
Mr. Suri, when I asked if the administration intended to reinstate the metering policy, I didn't intend to suggest that it was formally moot. And it was my understanding, I just wanted to clarify it, that the injunction in this case still has continuing effect on members of the class because it still matters.
That's right. There's a declaration that has continuing effect as to the whole class. There's also an individual injunction that has continuing effect as to one particular plaintiff, Beatrice Doe, whom the district court ordered us to allow into the United States. And that's an additional basis for avoiding any mootness concerns.
And that's why the Ninth Circuit said it wasn't moot.
That's right. And that's presumably why the other side hasn't raised a mootness argument, and why, even though we discussed mootness in our search stage papers, the court still granted review.
Thank you.
Justice Jackson.
So under Atchison Hotels, why wouldn't we still not reach at least the injunction? Because Mrs. Doe apparently has represented that she does not intend to return to the United States, and the injunction is specifically requiring the United States to facilitate her entry.
In the Atchison case, the plaintiff dismissed that plaintiff's claim and told the court that the plaintiff was abandoning her claim entirely and acquiesced in vacatur. There's nothing
she
like
she would have to do more, you're saying, than to say, I'm not coming back to the United States.
I think it's far too late to do any of that now, because we also have the class-wide declaration that independently keeps this case live.
Right. Let me talk about the class-wide declaration. You're asking us to reach the merits of whether or not metering is lawful and reverse the district court's judgment on that basis. Why isn't vacatur a permissible remedy here? I mean, I understand you'd like us to say today metering can be done, give you the okay to do it. But another way to address this, I would think, given that the district court declared a policy unlawful, even though the policy was no longer in place.
Hey, Chat, when she's talking about vacator, we talked about that with the Seventh Circuit issue of what the judge in Chicago had done that was way out of line. And they said, look, we're just wiping it out. We're wiping out all her orders. They're bullshit. We're not doing them anymore. That's one way to handle it, saying, nope, these orders aren't valid. And she's saying, I could do that instead of saying what you want to do is legal. But all that means is the judge is they're going to go back to that same judge, and the judge is going to say, nope, it's illegal. Don't do it. And I think that's the problem with her argument is the judges are going to say it's illegal again. We already know that.
Yeah, but be that as it may, I mean, that's sometimes just the reality of the situation, which is frustrating, but true. The Supreme Court will vacate a decision because the issue has, for some reason, is no longer procedurally proper. The vehicle is no longer good, and the issue is going to come back, and everyone knows it. And we'd love to resolve it, and then they just don't. So that's just, that happens.
Yes.
It's annoying, but it happens a fair amount.
Place. And the government today is saying it has no concrete plans to reinstate it. And the district court issued this order without making any findings about whether or not a live case or controversy existed. I think one could argue that the district court at least abused its discretion by nevertheless entering this broad declaration. So it would solve your problem, I think, if the court on those grounds just vacated it.
No.
Why need we get into giving you an answer on the merits of the question of whether or not metering is lawful?
The Ninth Circuit reached the issue of mootness and issued a ruling on that issue. I think it's the first footnote in its opinion. So unless you determine that that mootness holding was wrong, there's no basis for disturbing the Ninth Circuit's decision. And on mootness, we think the Ninth Circuit got it right. This case isn't moot because we'd like to reinstate metering and we're being prevented from doing so.
But you don't have a concrete plan. I just want to make clear.
Concrete plans are necessary for standing.
For standing.
Not for mootness.
All right. Let me just ask you one question about your response to Justice Kagan. You were talking about the various reasons why Congress had arriving in this statute, and that one of them you said was the fact that there was previously a distinction between deportation and exclusion, and that Congress was trying to ensure that that was also covered, or that the principles related to deportation and exclusion were covered by this new regime. My understanding is that exclusion applied to people who were, quote, at a land border, at a port. But your reconceptualization of what arriving in is doing does not allow for at a land border or at a port. And so can you help me to understand how Congress could both be attempting to ensure that those principles were included, but we still agree with your reading of the statute?
The phrase at a land border in this context refers to people on the US side of the border rather than the Mexican side of the border. And we know that in two ways. The first is the court's entry fiction cases, like Kaplan against Todd and Leng Mei Ma, repeatedly refer to aliens on the US side of the border who've just arrived.
In the entry fiction context, but we don't have a case or a scenario in which Congress makes clear that it's responding to the entry fiction when it uses the words arriving at, right?
And the second answer is that in Cardozo-Fonseca, when the statute said at a land border, the court understood that to refer to aliens in the United States.
Thank you.
Thank you, counsel.
That wasn't the answer she wanted.
It was not. It was not.
Ms. Corcoran?
Mr. Chief Justice, and may it please the court. In the 1980 Refugee Act, Congress established a statutory process for non-citizens fleeing persecution to seek protection in the United States. Congress designed the scheme to track the United States treaty obligation not to refile refugees to territories where their life or freedom would be threatened. Because refoulement includes, to quote Sale, defensive acts of resistance or exclusion at the border, the act requires immigration officers to process claims not only for non-citizens already present in the country, but also for those arriving at ports and elsewhere along the border. For decades, port officers followed the statutory procedures designated by Congress for inspecting and processing arriving asylum seekers. It was not until 2016 that the government asserted for the first time that it can wholly avoid these mandatory duties simply by blocking asylum seekers just as they are about to step over the port threshold. Petitioner's theory of the statutory text isolates the word in at the expense of making the rest of the statute nonsensical. By petitioner's account, the phrase arrives in the United States has no meaning not already covered by present in the United States. Arrives means already arrived, And amendments that Congress intended to encourage non-citizens to lawfully seek admission, in fact, did the opposite, permitting border officers to effectively eliminate access to asylum at ports. Petitioner's position is also at odds with the original public meaning of the provisions, reflected in the government's longstanding inspection practices at the time of IIRA's enactment, and in the government's own regulations, which have recognized for nearly 30 years that the Act's inspection and processing duties apply to non-citizens, quote, coming or attempting to come into the United States at a port of entry. As this court observed in Throssagum, Congress carefully crafted our asylum system to ensure that the United States lives up to its ideals and its treaty obligations towards non-citizens fleeing persecution. The turn-back policy flouted both, and the Ninth Circuit was correct to deem it the withholding of the government's statutory mandates. I welcome the court's questions.
How would you distinguish this case from Sale?
Yeah, this case is distinguishable from Sale in a number of ways. One, Sale involved the withholding provision alone. It didn't involve the statutory mandates that are at issue here in 1225, the inspection and processing mandates. So here we have a 7061 claim about whether the government has withheld compliance with those mandates. Sale is also different from an extraterritoriality and a treaty perspective because it involved interdiction on the high seas, which, as Sale explained, is outside of the jurisdiction of the United States. So it raises a host of questions that aren't raised here. I'd be happy to address some of the points my friend made.
Could you address 1157?
Yes. So 1157 is the refugee program. My friend takes the position that we have collapsed the distinction between the two. Our position reflects the way that 1157 and 1158 operated from 1980 to 2016. So for 36 years, no one was concerned about the distinction being collapsed, and that's because they serve two entirely different functions. Section 1157's refugee program is entirely elective. The president chooses whether to admit refugees. It's not something that refugees in other countries can apply for. It's decided between the countries. There are a host of benefits you get if you are admitted through that program, but 1157 is not the provision that implements the Article 33 obligations. That happens through the asylum processing that's under 1225 and 1158. And that asylum processing is also how you determine whether someone is entitled to withholding.
Mr. Suri gave some responses to Justice Kagan in saying that there's a subset of people who are arriving in the U.S. who are, as opposed to longstanding people. The problem with that is those people who are arriving, he says, are present in the U.S. So I'm not sure how his answer gets you around the surplus problem.
Yes, I agree. My friend made a number of new arguments about surplusage that weren't in the briefing, and I think that is one of them. But I would note exactly what you said. Making it a subsection doesn't mean that it's not redundant. It's still entirely redundant.
Well, that's true, Ms. Corcoran, that it's a subset, and so there's still redundancy. But I suppose if Congress in IIRA had just created this big deal about expedited removal and said that expedited removal was what arriving people got, it might be that they just wanted to emphasize that just because you were that you were subject to the expedited removal procedures did not mean that you still couldn't apply for asylum. So the fear, if you might say, is that if they had just had that one physically present provision and struck out what had previously been in the statute, the arrive at the port provision, somebody might have thought, like, all these people that are now being subject to expedited removal do not have the right to apply for asylum. And this provision is supposed to make clear that they do.
There's no reason for the inspection mandate to need to make that clear because 1225B, the asylum processing section, it's in B12A, has a whole process in place for how you assess asylum claims by arriving aliens. So that credible fear interview provision says if an immigration officer determines that an alien who is arriving in the United States has expressed a fear of future persecution, then the immigration officer shall refer them for a credible fear interview. And then there are a host of provisions that explain how that credible fear assessment plays into expedited removal. So there would be no way that someone could read the entirety of 1225 and be concerned about how it applied to arriving asylum seekers.
Can I ask you a question? I feel like there's some slippage between arriving and arrives, and as the Chief Justice pointed out, the language is arrives in. I mean, arriving sounds more in the process of, arrives in sounds more like you've reached your destination. How do you know under your theory when the person is close enough that we could say they have arrives in or arrived in the destination? I mean, what if there's a queue and they're far back? Or what if they arrive not at a port of entry? How close do you have to be to the border? Could you say that someone arrives in the United States if they're at a portion of the border that does not have a port of entry? Like, what is it? If it's not crossing the physical border, what is the magic thing or the dispositive thing that we're looking for where we say, now that person we can say arrives in the United States?
So I'm going to try and keep that in order in my head. And I'm going to start with the first point, which is actually.
I have a feeling this is not going to go very well.
It's the arrives in is the tense that triggers the inspection under 12258, but is arriving in is the language that triggers the credible fear interview. So that's the provision under 1225B that mandates asylum processing within the context of expedited removal. As the government acknowledges, and I think Your Honor just said, is arriving in does suggest a process. And in fact, that's exactly that determination is what's happening under the turn back practices. So they have immigration officers standing at the border asking arriving non-citizens, what's the basis for your admission? They get right up to the borderline. And if they say, I'm here seeking asylum, then the border officer turns them away when in fact 1225B says that if the immigration officer determines that the person is seeking asylum, he shall refer that person to a credible fear interview. So that argument stands separate from the inspection mandate. And what used to happen is that you'd have inspection and that's how you'd find out someone had a fear, and then that would trigger the credible fear interview. But both of those provisions are at play here.
Okay, can you answer the question about what is the dispositive thing that has to happen to say that someone arrives in?
Yes, so a person arrives in the United States at a port of entry when they are at the threshold of the port's entrance about to step over. So they are arriving there. I think that's consistent with ordinary meaning. I arrive at my house or I arrive in my yard when I'm going through the gate. Now that process of arriving is interrupted by the border officer physically blocking them from completing the arrival such that the person never arrived. But the process of arriving is beginning at that moment.
And is that just for the person? I mean, if there's a line, and you're far back and you hear, oh, no, we can't cross the border today. Have they arrived in and been turned away, or is it only the person initially told? And how could it be something different if you arrive at a port of entry versus if you cross the border or you arrive on the other side of the border, the Mexican side of the border, but say cross into Texas or try to cross into Texas where there's not a port of entry?
And so to start with the hypothetical where you have a line growing, I think that our position is not that arrives in the United States is doing no work at all. The question is what arrives in the United States at a port of entry means. And I think that means you have to be at the threshold. If I'm in a line waiting to get into my house for some reason, into my yard, and I'm half a block back, I haven't actually started the process of arriving in because I'm in a line waiting to get there. So I think, if the word was being passed down a line that's going over the bridge and people are turning away without actually getting to the threshold, they wouldn't fall under the statutory inspection mandate or processing mandate. The second question I think has to do with how arrival looks between ports. As a practical matter, the borderline isn't generally delineated in a way between ports that would allow for this kind of discernment about have you reached the threshold.
Doesn't the statute say whether or not at a port of entry?
Yes. So I was going to get to that part next. So we take out at the port of entry when we're talking between ports. And the question is, what does it mean to arrive in the United States? I think you would have to be at a place where you could, in fact, cross. So if you got up to, let's assume it's a place on the border where there is an actual line, identifiable line, I would say the same analysis applies, right? Have you made it to the threshold and you're about to step over?
So anybody at the water's edge of the Rio Grande on the Mexican side has arrived in?
No, the border is halfway through the water.
All right, so they've got one step short of halfway through. They've arrived, but somebody who's on the water's edge has not arrived.
Yeah, I think that's right. So you're looking at being at the threshold of when you're going to cross.
So somebody who's at the fence has arrived in, but somebody a step away from the fence has not arrived in?
Well, so the fence, so we're talking about the border wall.
Yeah.
That is, the border wall is entirely on the interior. So in fact, anyone who gets to the border wall is also physically present.
So anybody who's arrived at the fence is in?
Yes, but that's just a matter of geography that they're already present. To take the hypothetical though, what if there was a border wall exactly on the borderline? There, the analogy that I think of is a stadium. So I'm arriving at a stadium when I'm at the entrance going through the turnstile.
Okay.
I probably wouldn't describe myself as arriving in the stadium if I'm still on the perimeter making my way to a place where I can enter. So I don't think
So
someone
if
who's
they're
out of
top of the wall, they're in, but if they're at the bottom of the wall, they're out.
Oh, so now they've climbed.
Yeah. No, I'm just trying to understand what it means.
Yeah, so I suppose
we're going to get these.
You're the one saying
we're going to
it.
get as soon as we decide what it means, we're going to get cases.
Well, so as a practical matter, that's not going to be a concern because the wall is in fact within the perimeter. A hypothetical wall that was on the line and a person had kind of gotten to the top and was about to fall.
Then let's say Congress changes it, sweetheart. Congress changed the law.
But it's at a port of entry, right? So I think that if it's arriving in the United States at a port of entry, then it's not just any arbitrarily point along the border. It's at
Yeah,
a port of
but
entry.
how do I describe that? Am I in line at the port of entry? Do I make it into the turnstiles at the port of entry? Have I entered the building at the port of entry? What does port of entry mean?
I think it would be within the borders of the port of entry would work for my mind.
But what is that? If I stop you before it, is that where is the line? Where do you draw the line?
Well, the physical facility would be within be like, where's my house? It ends at the borders of the property line.
Yeah, I know, but you also have curtilage. You have different property. You have different regions of property too. So,
well, yeah, I understand that.
But
if you said I want to arrive, if you said arrive in my house at the front driveway.
No, but you told me, if you tell me you're at my, if you call me and say, hey, Sean, I'm at your house. That could be you're on the street. That would be at my house. And my yard's at my house. And my steps are at my house. And my front door is at my house. Yeah. Walking through my front door is at my house.
I think, but for the purposes of the legal analysis, I'm quite happy to say at the property line. So your house has a property line, and that's defined, and we call it there. That works for me.
Yes. I mean, hiding under the porch, on the roof. Yes. It's all of my house.
Over, I guess, potentially driving.
How come somebody who's in the line isn't in? I mean, if the whole point is to make sure that people who are attempting to get into the country have the opportunity to file asylum claims, and they've made it all the way, why does it matter he's second in line?
I think that's just a function of arriving in.
So the whole debate boils down to the one person who's at the port, the one person who's at the front of the line.
Yeah, and I think that's because I think it's important.
So the rest of the case, you agree with the government on?
No,
everybody else in the line, everybody else who's being metered doesn't have an asylum claim. Just the person who's.
They have an asylum claim. They have to get up to the border to present it. Now, I think maybe the question is if the government was stopping people from getting physically to the line, because if you're waiting in line and you just decide to abandon waiting and you don't actually make it to the threshold.
No. These people want to make these claims. They're there.
Right.
And they're being metered and they're told, no, not today. And you're saying the person who's made it up to the inspection officer gets to make that claim, and everybody else who's been waiting there maybe for hours or days doesn't.
Well, they just then, once they get up there, can make the claim.
But they have to get up there,
but there's no reason to think they wouldn't be able to do that. And I think it's important to remember that from 1917 to 2016, 99 years, there was not a single example of a turnback. So what was happening is people would come through the port. At that point, when they were in the port, they would be inspected and processing would happen. So it's an unusual scenario we have here where we have the officer standing there and turning people back.
And now we have these expedited removal processes.
What's that, Kurt?
I didn't say anything.
Oh, you said something, sorry.
At the border.
Yes.
So many of them are not getting in at all, but they're coming to the line and they're at least being questioned and permitted to make the claim.
Under the expedited, if they were being applied the way they're supposed to.
I think your point that you're making is the statute is very clear that anyone in the U.S. Now, the other side says a foot. I don't know why the foot is magical. I could put my hand through or my nose through. I don't know. Why does a foot count as opposed to a piece of your body count? So if you're up on the top of this wall that's not on the U.S. side. But my point is, in asking or clarifying this question, is arriving at the border means you're knocking on the door, correct?
Yes, that is what it has meant for 99 years before.
Mr. Surya suggested that's not what it meant, that's not what the federal regulations said, that's not what practice was. Was he simply wrong about that? In reading the papers, I understood that up until 2016, anyone who knocked on the door had the opportunity to make the claim, and they weren't guaranteed success, but they could make the claim.
That's right. So the government purports to cite a few earlier cases, which it says support its position. That's Lang Mei Ma, Hong Kwai Chu, Meze, the Ellis Island case. All of the cases that the government is citing, its sites are playing fast and loose with entry. So each one of those non-citizens was present in the United States, arrives in the United States, at which point they were subject to exclusion proceedings. That's the statutory process that you got if you arrived and then you weren't actually admitted or physically present in the country. That is all that we're just looking for, the statutory process to be applied to our class members, or we were when this policy was in effect.
I just want to make sure I understand exactly. There's a line of 50 people trying to get in. The first one knocks on the door. So maybe he or she is processed. I don't know how many people are there processing, but if there's one person there, maybe person 3 to 50, they don't have a claim, right?
Yes.
No, wait. Yes or no? Do they have a claim or not?
They are going to have it's going to depend on whether it's a reasonable delay.
Well, what do you think a reasonable delay is?
So that's under 706(1). I think Justice Sotomayor made the point earlier that the Ninth Circuit made a determination that this was complete withholding because there was no ability to wait. There was no ability to put your name on any sort of meaningful list that would ensure that
So so it's not knocking on the door, it's getting your name on it.
So it's a turnstile if you're at a land port and there's a plaque halfway across the bridge. So not a physical door. But yes, so when you go through the line, if it's working the way it should, you should make your way up to the borderline, at which point you come across and you are processed.
Maybe I just don't understand. I mean, it depends kind of on how long the line is, right?
Mm-hmm.
Yes,
Yeah.
there were non-examples prior to the turnback policy, even during the turnback policy, of there being kind of lines of people waiting to be processed who are outside of the United States because under the prior practice, you came through the turnstile and then you were inspected and processed. Now, there could have been long waits within the port. That certainly happened. And that would have been subject to kind of a reasonable delay analysis. But this idea of kind of lines and people piling up on the Mexican side of the border didn't happen until the turnback policy was put in place. And you got this bottleneck of people waiting on that side.
No, I understand that, but I'm still struggling with the Chief's question. And we do have situations where there are lines. And I had thought you'd said to me and Justice Sotomayor or others that the first person at the turnstile with the inspection officer has arrived, but people further back in the line haven't. And now I thought I heard a different answer to the Chief Justice. And I'm just wondering, I really do, whatever you think it is, I want to know what it is.
I think I was skipping ahead when I answered the Chief's question to kind of the nature of the 706(1) claim and the difference between withholding.
I'm just curious what arrives in means.
Arrives in means you reach the threshold. I didn't mean to create confusion about that when I was
Okay, so it's the person at the turnstile, it's the person halfway through the Rio Grande, not somebody 2 people back, not one person back, not one person who can't reach across the halfway point of the Rio Grande, none of them.
Yeah, you have to reach the threshold in order to be subject to the 1225 mandates for inspection.
So how does that fit, Ms. Corcoran, with 1225B1A(i), which says if an immigration officer determines that an alien who's arriving in the United States is inadmissible, the officer shall order the alien removed from the United States. Now, to me, that suggests not you remove somebody from the United States when they already have crossed the threshold, not when they are knocking at the door. So that suggests to me that arriving in suggests that they've already crossed.
So it's a process of arrival. So the person is arriving in when they're about to step over the threshold. And again, I would go to the plain meaning and I think about kind of being in a house or a yard. If my husband called and said, "Are you arriving at the house?" as I'm walking through the door, and I said, "No," that would be a strange answer to give him. The ordinary meaning is, yes, I'm.
Well, but if it's arriving in, the officer shall order the alien removed from the United States. That seems to suggest that your view of plain meaning, whether it is plain or not, is not the statutory meaning, because if you're removing somebody from the United States, that person has clearly made it over to the United States. You don't remove somebody from the United States when they're just knocking at the door.
Well, so I think that provision makes sense if you remember that removal is a legal term. It refers to removal proceedings. So what that provision is assuming is the completion of arriving. And because in 1996, when Congress was drafting the language, it had no reason to think that 20 years later, the government was going to change its position and start blocking people while they were in the process of arrival. So you see in the regulations, and I think also in SAIL, kind of the understanding that the process of arrival starts when the person is at the threshold and it continues as they step over the threshold and are being inspected. So I don't think there's an inconsistency there.
And so to clarify, when the person is arriving at the threshold, the process of inspection, you say, kicks in based on their arrival. And that process could take place on U.S. soil, presumably without metering. The inspectors are on the U.S. side, and so they're asking and they're investigating, and the person is in the U.S. at that point.
True.
But the obligation to do that kind of inspection, I think you're saying, kicks in based on the person's arrival.
Yes, that's exactly right. And it makes sense when you remember that that is how it had worked from 1917 to 1996 when Congress was amending the proviins in IRS.
Can you speak a
little? It'll be interesting to read the actual transcript of the oral argument, because I believe that both you and Justice Sotomayor and Justice Jackson on several occasions have used the phrase arriving at. I think you said you arrived at your house, but that's not the term that is in the statute. Do you think there is no difference between arriving at a location and arriving?
Oh, wow. They're A-logging each other now, chat. This is actually a little bit, like, this is actually kind of significant, them calling each other out on the record like this.
It's a little bit, yeah.
Just a little bit. We got some A-logging on here from Machine Gun Sammy.
Arriving in the location.
Yes, thank you for the opportunity to clarify. So we have in the United States at a port of entry. I can explain the amendment history on how we ended up with the prepositional phrases in that order. But I think that my first order answer is in is just how you describe being in a region. You wouldn't say at the United States. You would say in the United States. I'm arriving in Baltimore when I'm on the train as it's coming in. I am at Penn Station when I'm in New York. So that's the difference in prepositional phrases, which even if it doesn't completely answer the question, does give you some pause to say, well, maybe in isn't doing the work that the government is suggesting here because it has to do with kind of the natural way that we talk. But the way we ended up with that order of the prepositional phrases is that
Well, I'm not quite sure I understand that. So there's been talk about knocking at the door. Do you think someone who comes to the front door of a house and knocks at the door has arrived in the house? The person may have arrived at the house.
No, but that's past tense. Are they arriving in the house?
Does a person arrive in the house when the person is not in the house and is knocking at the door, asking to be admitted to the house?
Yes, I think here the door is open. The officer is standing on the other side of the threshold. The person gets there and is ready to take the step over, right? The officers and the asylum seekers here were toe to toe. This was happening right at the line, and they're about to step over. They arrive in present tense. Once they're inside, they've arrived past tense, but we know that Congress used the present tense here.
Well, it does make, I gather you think it makes a difference. Whether there's a door or a turnstile, you have to be there. If you're at the end of a long line, you're not there. You haven't arrived at the turnstile.
Yes.
Okay, so then it doesn't matter how many people are processing the arrivals? I mean, how quickly the line's going to move. I mean, it strikes me as a very significant factual question. In other words, it's not, if you're at the end of the line, you're not covered by the requirement to process. Is that right?
Yes. So once you get to you have to arrive, and that's just the nature of the language that Congress used. However, if the government was complying with the inspection and processing mandate, people would be going right through the turnstile. There is no stopping or processing that happens at the turnstile under the prior practice. A person goes through, and at that point,
so you don't even have to knock.
No, there was no knocking. You went through. There's no immigration officer who was stopping you. You're going straight through the open door. You are now in the inspection area. You're in the port. And at that point, there would be perhaps a delay of processing for the reason you say. That delay would be subject to 7061, unreasonable delay. Here we had a complete withholding.
No.
But I think maybe where we're getting stuck is kind of the idea that processing is happening at the border. That only happens under the turnback policy. That's the only situation in which you're going to have immigration officers interacting with asylum seekers on the other side of the
So historically, if you were at the end of the line, you still went through.
There was no line. People just
Right, there was no line.
Yes,
this only became an issue, is what you're saying. And so the arrives in wouldn't.
There was never a line because there weren't millions of people doing this. We're in different times now. There are lines because there are literally millions of people trying this crap.
Have had the significance in 1996 is what you're based on the historical practice. And now we're trying to figure out what it means when there's a new practice not envisioned by Congress.
Yes, that's right. And if I could go back to something you said earlier, which is the logical problem the government has with treating this kind of the change in language as if it suddenly substantially narrowed access to asylum at the ports. Not only is that illogical, but it defies the express purpose that the text was seeking to achieve, to quote Justice Scalia. We know that the reason that Congress amended 1225A1 was to expand the category of applicants to include people who were already present in the United States and people who entered between ports because it needed to put them on equal footing. So to read that language as then disadvantaging people who attempt to enter lawfully makes no sense at all.
Can I ask you, this is a new practice. Justice Kavanaugh just said a new practice not envisioned by Congress. The Chief Justice says we have a significant factual question here about how this actually works. Why wouldn't we wait until we had an actual policy with real facts in the record regarding what's going on? I mean, even if this is not technically non-justiciable, even if there is jurisdiction in the literal sense, we do have some control over whether or not we reach and discuss issues. And it just seems to me that we have a lot of hypotheticals regarding how this policy may have worked in the past, how it's possibly going to work in the future, but we don't have a policy in effect right now that we can actually rule upon. So how should we take that into account as we think about this?
Yes, thank you, Your Honor. So as we explained in pages 15, I think 21 of our brief in opposition, this case has virtually no ongoing significance, certainly not for the plaintiffs. Now, the government has sought this court's review because it wants to preserve its degrees of freedom in the future. Right now, the border is closed under other authorities, but maybe that's not true in the future and conditions change. That is not a reason for this court to grant plenary review. The government suggested—
I mean, if the government were to just bring its own action, I think Mr. Suri has conceded that they wouldn't have standing because they don't have an actual plan in place that they're trying to implement.
Yeah.
What they're doing is saying we have this, essentially extant district court order out there. And at some point in the future, we might want to have a policy like this. So Supreme Court, tell us now whether or not that's going to be unlawful.
Yes, that's what they're seeking. That doesn't, in order, as the court said in Camreta v. Green, both parties have to have a live interest in the case in order for the court to proceed. And that explanation doesn't go to how plaintiffs continue to have an interest in a declaratory judgment against a policy that was rescinded 5 years ago. And so I think it's odd to raise the voluntary cessation exception here, where it's the defendants who want to continue
Absolutely.
to do the policy.
Usually voluntary cessation is the defendant wanting to avoid the court's orders. And then they remove the policy so that the court doesn't order.
Right.
Here we have them pointing to the voluntary secession as a reason
I know,
for the
Chad, you
court
don't
to
understand. I told
weigh
you.
in on this policy.
We hit it up
Right, and
early.
it's the government that's saying, the government has control over the extent to which it's likely.
Counsel, do you think the Ninth Circuit was wrong to say that it was not moot then? You didn't challenge that in your brief.
No, so what the Ninth Circuit said
Thank
that
you,
the
EDW.
declaratory judgment was moot and the dissenting judge agreed. The reason that the Ninth Circuit reached its holding was because of the transit rule injunction,
Right
that
back, Chad.
smaller class, which at that point, that injunction was still in place and it imposed a number of obligations on the parties. So the Ninth Circuit was not wrong about that. But on remand, the parties agreed to essentially dissolve the injunction because the burdens that it was placing on the parties no longer had any benefit to the class members. The class members had been identified.
So you're taking the position it's formally moot.
I do think it's moot for the reason.
Why didn't you make that point in your brief?
We wrote 6 pages of all the reasons.
bio?
Yes, in the brief in opposition. It wasn't until the reply in support of cert that the government suggested Munsingware vacator. I'll say we don't object to that. We didn't address it in our brief in opposition because that would be an odd thing for a respondent to suggest. And once the court granted review, we focused on the merits. But to Justice Jackson's point about Munsingware vacator, we don't have an objection. And I think that resolves all of the government's concerns in this case.
Thank you, counsel. Justice Thomas? Justice Alito? Anything further?
On that last point, the court said that declaratory judgment, it was vacating that. And then and it's also vacated the preliminary injunction?
No, so the declaratory judgment is still in place, but I think is moot for the reasons that the Ninth Circuit said. The Ninth Circuit went on to reach kind of the statutory interpretation question, not with respect to the declaratory judgment, but with respect to the transit rule injunction, which would only be in place if the underlying statutory question was resolved in the plaintiff's favor. But then that injunction was dissolved. So we really have nothing that's before the court at this point.
Thank you.
Justice Kagan?
Is your position that when a person gets to the border, she has a right to apply for asylum only, or that she also has a right to enter?
So enter so a right to cross, I'll say cross.
A right to
avoid,
cross.
The entry. So I think the right to cross is tied up in the inspection and processing mandates that are on the government. So we have a 706(1) claim here. It's based on ministerial duties that attach the government under these circumstances.
And if the United States figured out a way to do its various things that it has to do without having the person cross, would that be sufficient? You could have a Zoom interview or something like that.
Yeah, I suppose that 1225 assumes that all this is happening on U.S. soil, and I think for good reason, because that's how it already worked. The government's extraterritoriality concerns might weigh against doing some sort of process, but I don't know that I have a stake in pushing back on that way of approaching things.
Okay.
Justice Gorsuch, anything further?
Just briefly, you mentioned the Court of Appeals revised opinion. It said it didn't think the case was moot because of the equitable relief still present, which I took to mean both the declaratory judgment and the injunction. Am I mistaken?
So yes, they were both left in place. The reason that the Ninth Circuit reached the underlying statutory interpretation question was
Because they were both in place. Yeah. Okay. Thank you.
Justice Kavanaugh?
On that question that you made a point on about why Congress would give better treatment to those unlawfully in the country, I guess one response to that, just want to get your reaction, would be we should just interpret the rule in front of us or the statute in front of us by its terms and not try to figure out all the things that might be going on with people unlawfully in the country to try to make it all fit in some perfect world. Rather, we should, there are lots of issues with people who are unlawfully in the country but the only issue before us is trying to figure out what arrives in means and not worry about that. Just want to get your reaction to that.
I think that's a great argument too.
Sorry, I'm not sure I followed the question.
You were saying that if we interpreted it the government's way,
Yes.
that Congress would have been privileging people unlawfully in the country. And my response or my question to you is, whatever's going on with people unlawfully in the country, the sole issue before us is trying to figure out what arrives in means when you're at the border, and whatever the effects of that are in terms of creating disparities, we can't sort all that out here. All we have to do is focus on the issue before us. So what's your reaction?
Yes, thank you. Sorry, it took me a little bit to get there. So I think it's less about advantaging people who are already in than it is about addressing the disparity incentives that Congress was trying to resolve in 1225. So under the government's framework, if you are an asylum seeker coming to the United States, you should not go to a port because you will be turned away. You need to cross the Rio Grande, you need to come in between ports. That is the exact opposite of what Congress was trying to accomplish there. And I know also—
But the answer to that could be better enforcement of people coming in unlawfully, and Congress might have assumed, particularly—
Notice, you know what her answer is going to be to that? No, don't keep the heckin' immigrants out. No! That's going to be her argument. But that's mean, Judge. We shouldn't do that. I know there's I don't know if you follow on Twitter, Kurt. There's the guy. He's like one of these immigration attorneys. He's got like a big soy face profile picture, and he's complaining about like ICE not doing this or that. I'm like, just admit you just want no fucking immigration laws, buddy. Like, and for her, I just think everybody should come in. It's like, just say that. Just admit to it.
But it does sound backwards because it seems to me the better policy is if you come in illegally, if you cross the border illegally, not—
Well, we need to address the rest of that and say, if you're here, get the fuck out too. That's
well, that too. But if you are to apply for asylum, then where would we want you to do that? It seems the logical answer to that would be at a port of entry, because that's where the U.S. officials will be to receive your claim. And then the processing of that can look a lot of different ways, but that's where it be. And if, they're so overwhelmed they can only see so many people that day, then, that's fair enough, but that's just a pragmatic concern.
Yeah. There's the first country of origin. That's another program. There's all kinds of stuff we can do. But these people don't want that, and they should just admit, like, that's not what they want. It's kind of like the Cato Institute guy when he's like, well, immigrants bring in more money. It's like, just admit you don't want any immigration laws. Like, let's quit lying about it. Now, what's illegal? Okay, nobody, if she said that would let the cat out of the bag, though.
1996, when there was an increased effort to prevent illegal immigration, that people wouldn't be flooding in unlawfully. That turned out not to be accurate, but that might have been the expectation in 1996. So,
but I don't think that then explains what Congress was doing in 1225. It creates this applicant for admission category in order to unify the proceedings, the deportation and exclusion proceedings. What the government is suggesting just makes all of that somewhat nonsensical.
Okay, completely different question. Last one. This seems very artificial, trying to figure out at the threshold, on the line, in the middle of the river, because wherever the line is, the government's presumably going to stop you on the other side of that line and prevent you from getting to wherever the line is, right?
So that you're getting across the line.
Yeah, so if we define it as the threshold, the government's going to stop you short of the threshold, or try to.
I understand.
And if we say 100 yards from the threshold, they're going to stop you 125 yards.
And this is my point. Like, if you say that's a case, then fine. The U.S. government will work with the Mexicans, and they'll just start interdicting people 20 miles from the border and say, sorry, you can't come in. I mean, there's always a way around this.
In the threshold.
In other words, the point. Like
what?
The air deck people 20 miles away from the border. No, I don't quite understand that. What are you saying?
Well, he's saying, and I agree with Kavanaugh, you're saying, okay, well, you can't do it right at the threshold. Okay, fine. I'll go 100 yards in front of the threshold and say you can't come in. Now you're not at the threshold. You're 100 yards away. And then if you say, well, within 100 yards of the threshold, I'll go 101 yards away from the threshold. I'll go 150 yards away from the threshold. Like, the government can always push further and further south away from the border.
But if the government is the one that's preventing you from approaching the point of entry, then that's governmental action.
I understand, but that's going to be a separate, like, I assume she's going to address it here, but let's see what she says. But that's what he's asking. Like, what's to stop the government from doing that? And the answer really is nothing.
Well, I think the answer would be that if the law allows you to apply for assuming the law allows you to apply for asylum at the point of entry, if it's the U.S. government that's preventing you from doing that, they can't do that. Because you're
understand.
You're entitled to apply at the point of entry.
And but the government's saying, sorry, you can't.
Yeah, but they can't do that. That's the whole problem, because that seems to be what the statute seems to require. Am I right?
No. I mean, that's what I think her argument's going to be. But let's see what she says.
I guess the arrives in thing seems kind of artificial. The whole question, the bigger question, it seems to me, is can the government physically stop people before they get to wherever that line is, no matter how we define it? And that seems like not a statutory question, more of an arbitrary and capricious question, but maybe I'm wrong. Just want to get your reactions to that. This whole idea of you're second in line, or for the government, wherever we define it, is going to stop you when they want to implement this policy on the other side of that line. You follow that?
I do. And so I think that maybe the factual premise is inaccurate there. The port goes right to the borderline. So the government understands ports as being kind of that geographic space. So the threshold of the port is the borderline. So you can't really, if you move the threshold further in, then you have people who are present in the United States. If you move the threshold further out, well, now we're in Mexican territory and the government doesn't have authority to act there. So
well, that's okay. So that's a good answer. Does the government, how far into Mexico, maybe the SG, will the government go?
If the Mexican government allows the U.S. government to do it, they could have an agreement worked out. Like, that's not, she's like, that'll never happen. It's like, are you sure about that? Because they could agree whatever the fuck they want.
They don't want to answer that, to stop people.
Yes. I think if the government starts going well into Mexico.
Well into, is that 100 yards? I mean, 150 yards? That's not the threshold anymore. And will they go into, I mean, again, you might not have the answer to this question, but the whole thing seems kind of artificial to me, because the government is going, if they want to do this policy, they're going to stop you on the other side of the line.
Yes, and I would say there that so if we start to have the government kind of circumventing further into Mexico, whether it's 10 feet or 100 feet, we move out of the inspection and asylum processing mandates in 1225. And now I think it's a question of just kind of ultra vires acting without authority in another country.
All right. Thank you for your help.
Justice Jackson?
We don't have the answers to Justice Kavanaugh's good questions because there is no policy in effect, right? We don't know.
That is right. I was going to make that point as well, right? Right now we have a legal question that's unanchored from any actual practice before the court.
Thank you.
Thank you, counsel. Rebuttal, Mr. Suri?
Just a few quick points, Mr. Chief Justice. First, this court should decide this case. The case is not moot because there is still effectual relief that the court could award, namely lifting the class-wide declaration and the individual injunction to which the government is still subject. There's also a strong practical reason for the court to decide this case. Administrations of both parties since 2016 have consistently said that this is an important tool in the government's toolbox for dealing with border surges when they occur. I can't predict when the next border surge occurs, but I can say that when it does occur, this is a tool that DHS would want in its toolbox. It's not something the court should leave to future uncertainty. We've been faulted here for not having a specific policy in place, but that's not really fair to us. There's a class-wide declaratory judgment saying that this practice is unlawful. And I think the government should not be faulted for conforming its current conduct to what a court has declared to be the law. Once that declaratory judgment is lifted, we'll take appropriate steps at that time. Second, the text of the statute should control the court's decision, and that text arrives in the...
There you go. I think that's clear. If you clear us, we're going to do it. I think, we'll take the appropriate steps. I think it's a pretty clear statement of what they're
Fair
going to
enough. Maybe that was clear. Okay.
I don't know. To me, that says we're going to do this if you let us do it. I'm like, well, let the cat out of the bag.
the United States. We've heard attempts to substitute other language that might be more ambiguous or more susceptible to respondents' interpretation than the language Congress actually used. For example, we've heard many references to arriving in the United States, but the specific language at issue here is arrives, not arriving. Further, as Justice Kagan correctly pointed out, there's a separate provision of Section 1225 that says that arriving aliens can be removed from the United States in certain circumstances. And that suggests that even the arriving category is limited to aliens who've already crossed the border. Even if you think that there is some ambiguity in the term arriving, though, the correct approach is to use the clarity of arrives to resolve the ambiguity in arriving. You shouldn't use the ambiguity potentially in arriving as an excuse to ignore the clear word arrives. Similarly, we've heard attempts to replace arrives in the United States with arrives at a land border, or arrives at the threshold, or knocks on the door. None of those terms are the terms Congress actually used in the statute. Moreover, even when a previous version of the statute said arrives at a land border, this court still interpreted that to refer to aliens in the United States. We've relatedly heard a suggestion that the alien arrives at the port of entry because the port goes right up to the border. We don't think that's accurate. The entrance to the port might be something like a quarter mile from the border. So even if you think the question is whether the person arrives at the port, the person hasn't arrived at the port. More importantly, the real question is whether the person arrives in the United States. Finally, respondents' position raises serious line drawing problems. It's not clear from their position whether you have to be at the front of the line, the back of the line, or the middle of the line. It's not clear whether they're distinguishing between someone who is stopped by a border officer versus someone who is stopped by the Rio Grande versus someone who is stopped by the border wall versus someone who is stopped by Mexican authorities working in concert with the United States, which is something that could happen in response to Justice Kavanaugh's question. I don't think we ourselves go into Mexico, but we could cooperate with Mexican authorities to stop people from reaching the border of the United States. Our position avoids all of those line drawing problems because Congress drew a clear line here. It said that if you're outside the United States, you can apply for refugee admission under Section 1157. If you're in the United States, whether you've been here for a long time or you've just arrived, you can apply for asylum. The court should respect the line that Congress drew.
Thank you, counsel. Case is submitted.
All right, there we go, chat. So.
Later this afternoon, President Trump is hosting a swearing-in.
Mark Wainbolin. New. And that's very fitting that it says the case is Noem versus Orto, Lado.
Yeah, someone's got to rename that.
What's that?
Someone's got to rename that.
I know, but it's very funny. It's very apropos. Like, immediately they go right into the new DHS secretary being sworn in.
No, just do a little substitution when you issue that one.
It's funny how life be like that sometimes. I kind of get the feeling this is probably going to be like a 6-3, if I had to guess. I don't think the court's going to side with the respondents. I don't know about you, Kurt.
It does seem, to go to the policy issues, it does seem pretty batshit crazy to say that Congress said, okay, because the statute says that any alien who's physically present in the United States, and even goes so far as to say whether or not at a point of entry, can apply for asylum, irrespective of their status. So if they're in the United States, they can apply for asylum. So the people who cross the border illegally, as long as they're here, they can apply for asylum. But the person who actually tries to go to the port of entry to apply for asylum, if they're turned away, can't apply. Now that seems completely backwards, because you'd want it the other way around. If you cross illegally, how about not so much for you? But if you go to the port of entry, which is the responsible thing to do, then you can apply for asylum. So this is leading to the exact opposite of what you'd want.
I think, honestly, this is the immigration law sucks. And that's because routinely throughout history, we've heard, oh, we've got an immigration agreement between the Gang of Eight or the Gang of whatever. And it's going to be, we're reforming immigration, pathway to citizenship. Oh, and then we'll work on border security. In the meantime, they've turned immigration law into a complete dumpster fire where, like you said, there are these weird perverse incentives to sneak into the country, and then, you have these perverse incentives to sneak into the country and then claim asylum. Which, yes, it's stupid, but that's because we've had very crappy legislation on this.
It seems to me. I mean, if you were the administration, I think my thought is let's go completely the other direction. It's like, if you come to the port of entry, and which is what we want you to do, we're going to put you to the front of the asylum line, because all those people who cross the border illegally, they can apply for asylum because that's what the statute says. We can't avoid it.
Well,
but what we can do is anyone who actually takes the time to arrive at a port of entry, we're going to put you at the front of the asylum line. So that creates the incentive for people to go to ports of entry.
There's an easier incentive. We're not going to recognize any asylum claims from anybody here. Our immigration judges will deny them all, and we're still going to flare everybody. I think that's the tack that the administration's taking instead, which I think is, you know what?
I'm just talking about the ability to apply for asylum.
Oh, I agree, but we're just saying you're all by afuera, as they say in Espanol.
Well, to do that, you might need to change the law, which I'm not necessarily opposed to doing in the first instance. Maybe we shouldn't have the immigration or asylum policies we do. But of course, at least for me, I'm stuck with the statutes I'm given.
Oh, I understand, but that's why I'm saying if I'm the DOJ, I could say, because I control the immigration courts. Remember, all those immigration judges are, I control that whole process. I want asylum. No,
well, you only control it, but the judges have to apply the statutes.
Yes, and the statutes are, as long as it's not completely insane in its logic, like with these TPS situations.
Sure.
As long as it's somewhat reasonable and it doesn't defy logic. Ryan Mullally and I read through
That's
this.
fine. So if the administration wants to say basically we're going to interpret this to give the smallest asylum claims that within the bounds of the statute, I have no problem with that.
And I think that's how they're working around the fact that Congress will not do what they want.
Yeah, that's fine. That's fine by me. They can find the narrowest interpretation of the statute. As long as it's within the bounds of the statute, I have no problem with that.
Yes. EDW Raptor says if I was at the DOJ, I would ask for a PB&J. I mean, it all depends. Like, what kind of jelly do they have? Like, is it grape jelly? Because I'm not a big grape jelly guy. Is it strawberry jelly? Oh,
Apricot.
yeah.
Apricot's pretty good.
With peanut butter?
Yeah.
I'd have to try that. Never done that one before. But like,
you always do the Ellis thing and just do honey instead.
Well, yeah, peanut butter and honey is really good. But there's also blackberry jelly. Blackberry jelly.
That's a good call. That's a good call. Best. I respect that. Yeah.
Peanut butter and justice sounds like a good sandwich. If you pass through 3 other countries before claiming asylum and a 4th, is it really asylum? No.
Yeah, and that would be a really good basis for an immigration judge to be like, well, you didn't really mean it because there are a lot of other places for you to go. And this is not fundamentally our problem.
And, we see all
why are we the dumping ground of the entire world? This is not our problem.
Yes, and we're now learning, too, that more and more throughout the immigration laws, there are people just claiming, oh, well, a bunch of people don't like me where I'm from. Why don't they like you? Well, it's not an excuse. It's not asylum. It's got to be they have to hate you for a particular reason.
Yeah, I keep thinking about applying to be an immigration judge. It might not be a bad idea, and I'm happy to deny.
It'll probably be it'll look like be a 2-year gig, Kurt.
Hey, it's fine by me. It's fine by me, and I'm happy to deny deny to the maximum extent allowed by law. I'm not exactly eager to grant asylum claims.
Kurt afuera molar, just afuera. The guy's like, but I'm from Somalia. Learn Spanish. So there's some actually good questions here I was going to catch. None. Okay, None. 1790 says, are the Supreme Court courts taking notes during this? No. This is, by the time you get to an oral argument, the judges pretty much know where they're going. They're more asking these questions to poke and prod, to flesh things out for the other side or other justices. This is not a, nobody in there really gave an argument where Clarence Thomas is like, I was thinking the other way, but I agree now. So no, this is not, it really comes down to the briefings, and most of what they're going to argue anyway sticks in the briefing as well. So there's no need to take notes anyway, because they would have transcripts for this stuff at the end of the day. But that's a very good question. It's a very, very good question. EDW Reps says, I think KBJ's. Yes, thank you, EDW.
Supreme Court hot?
I guess hottest woman on the Supreme Court. If that's the race you're running, I guess. All this sounds like Victorian dirty talk. Yes. Oh, my betrothed, I'm going to arrive. I'm knocking on the door. I'm in your threshold. Yes, it's true. Thank you, Jasper. I'm surprised Phil lets you donate like this, because that would have probably been, part of a pull for WWE. That's part of a Hogan pull. Nobody knows it says Alito looks better as a woman than Jackson does. Oof. Trans Alito. Oh, that's a horrible universe. Okay, I'll bring this one up because I promised to read them all, and I'm going to promise to read them all real quick.
Oh Lord, that was a
Bob
mistake.
for $2 doodle says at the end, Vivek Katanji $1,000 he wins. Well, like $1,000 American dollars, or are your dollary dues. EDW Raptor for $5 says, chat, did you know we're 138 days from Sean's birthday? Yes, it's 138 days away. We are so close, I guess. Luke has been a member for 1 month. Thank you, Luke, for re-upping. Says, happy birthday, Sean. It's not my birthday for another 138 days. Muralist actually asked a good question here. Says, why is the name Noem, for example, instead of the secretary, something like the office? Because if it's the secretary, well, who is that? Who is the secretary? Right now, Kristi Noem's not there anymore. So who's the secretary?
Because that's the way we do it, bitch.
Well, there's that too, but it's also, you need to identify a person. Because it's just, if this monolithic institution, well, who's the person responsible? You have to be able to and you do the head. That's why it's like Trump, if you're suing certain things, or Pam Bondi would be certain things, or Pete Hegseth. That's why you see these cases like Rumsfeld versus like Hamdan and Hamdi and Padilla, because Rumsfeld was the Secretary of Defense. Or Ashcroft v. Iqbal, because John Ashcroft was the Attorney General at the time. But that's the way it's always done. You have to have an identified party like that. You can't just name an institution. But yes, more or less, because it's the way we've always done it, is correct from Kurt as well. I own you, says, grape jelly is the best. I'm unliking the stream now. Well, Safa. It's not the best. Not at all. KJ says, why change the laws when they can mean whatever a judge says they mean? Well, I mean, there is that issue as well. But because it's the way you're supposed
partly
to
make changes, partly to change what the judge says it means.
Yeah, but I think their point is all it takes is, Hawaii judges say, no, I don't like that. And it's like, fair enough, but we're supposed to do it the right way. And I understand it's hard, but yes, we are supposed to do it the right way. Does secretary do her own typing, or does she have a secretary? Yeah. Oh, thank you. A very good one. Kill Billy says, I want to cite the case of Hose versus Mad. Jasper the Cat Dude's correct. Darkside Phil's an immigration judge would say, nothing I could do. Ban. Deported forever. So yeah, that actually maybe is calling. Just deport everybody all day long. Oh, let's see here. Has Justice Dankula made women illegal yet? No. And then Meet Copium chat, he says, all these grape apologists in the chat. I know. All these grape supporters. It's just ridiculous. Dave Hill says, aren't activist judges the worst? Yeah. I mean, they're not fun. Yes, JDK Buck, correct. You said fee, but I'm going to call it a tax. I mean, yeah, that does happen sometimes. Like it did. I like it when Sean does crowd work. That's kind of part of how this works. What would be her title? What would the secretary's secretary be titled? I don't know.
What?
I don't know. So, like, if the
I don't even understand the
secretary, if the Secretary of Homeland Security has a secretary, what's their actual position? Are they the secretary's secretary?
Yeah.
I mean, I know, but would you call them secretary squared?
No, I'm pretty sure not.
I don't think so either. But I'm not a math guy, so once you start adding things, I start thinking it's voodoo. As an attorney, I recoil at the concept of math. Spudgun says, I refer you to the case of Prestrom versus Arkell in 1971. I don't know what that is. Hold on here. I'm going to Google this just to see what happens. I hope it's not like goatee porn.
This isn't going to end well, I'm pretty sure.
Yeah. Let me see here. Is a famous succinct legal reply from a private eye magazine to a libel threat.
Just fuck you.
Okay, so there was a demand letter, and the magazine responded, "We refer to your letter. We note your client's proposal, and we tell you you may go to hell." It's like, yeah, that sometimes succinctness is correct. That is correct. I knew it. I didn't know that was the name of the case. I'd heard it before. I refer you to Spy versus Spy. Yes. Secretary twice removed. Kill Billy says, what's your take on Marbury versus Madison?
Oh yeah, I think it's correct. I think it correctly decides. I think it is correctly interpreting Article 3. The Article 3 says that the Supreme Court has jurisdiction over all cases of law and equity, and so that they are to provide legal interpretations. So I think Marbury versus Madison is just Article 3. That's what I think.
I mean, I don't disagree. I mean, it does sound, the idea of saying like, oh, Marbury versus Madison's bullshit sounds great until you realize like then the Supreme Court's gone and has no purpose. Like, what do? Every once in a while when an ambassador gets in trouble or there's an impeachment, like that would be kind of weird. So,
yeah, so I'll just read it. Judicial power shall be vested in one Supreme Court. Yes. Okay, well, what is the judicial power? Isn't it the power to decide what law means? And it says judicial power shall extend to all cases in law and equity.
Yeah, I agree.
Arising in the Constitution. I'm explaining it to the chat.
Oh,
the laws of the United States and treaties made. All right, so remember that the Constitution itself says that the Constitution is the supreme law of the land. So the Constitution is a law. And so if you were a court interpreting just any other law, like, I don't know, a speeding law, and you're saying, what does it mean? Like that, no one has a problem with this, right? So the court's just interpreting the law.
Mm-hmm.
And so then it's like, okay, well, what if you have a conflict between laws, right? What if two laws are fighting each other? How do you deal with that problem? Well, since the Constitution says it's the supreme law of the land, that means that if you had a conflict between a statute and the Constitution wins. So if you interpret, well, this means this, and this means this, and this contradicts this therefore is illegal because this says it's supreme. So to me, it's just, Marbury versus Madison is just Article 3. I don't understand I don't think it's inventing judicial power. I don't think it's, I think it's just Article 3. I think that's what it says.
Mm-hmm.
I know certain other learned scholars of the law tubes who passionately disagree with this position, and I look forward to their coverage.
Yes. Next week, Moments of Trading is going to become a Third Amendment auditor. It's going to go house to house checking for unwanted soldiers.
Nice.
There you go. I have a feeling you will be chasing a white whale for a very long time if that's your goal. But you can also claim by you doing your job, you're making sure it doesn't happen. So you're like, you're the guy breaking windows and then you also fix them. Who would have won in a duel between John Marshall or Andrew Jackson? Probably Andrew Jackson. That dude was tough as nails. He wasn't afraid to kill people.
Old Hickory?
He killed people in a duel before. So I feel like there's going to be a father-in-law with the no good bum of a soldier's son-in-law. Well, JDK says the Third Amendment applies it to times of peace.
Yeah.
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 Yeah. I mean, and, well, along with the Third Amendment, it also, turns in all kinds of different issues there. There's a Fifth Amendment issue, too, if you have a, quartering people. But that was done solely to have basically a surveillance monitor in your house. It also meant you had to care for them, and it alleviated the strain on the British government because you're responsible for feeding and bathing him and washing him. And you didn't have to give him a sponge bath, but he had to have hot water. You had to take care of him. JDK says at times of war. Well, yeah, if there was a time of war, if they're putting soldiers in your house, like if they knock on your door and says, here's Private Snuffy, he's sleeping with you tonight, we've got bigger fucking problems than the Third Amendment.
Yeah.
So yeah, it's yeah. Old style canes were lead weighted for self-defense reasons. Yes, they were. They were. Yes, he beat a man with a cane who tried to kill him. Okay, Kill Bill has a real question. Says, do you think the Supreme Court should be expanded? With only 9, it seems like they miss a lot of important cases.
I think that they should take more cases. There was a time when they took a lot more cases, although for a while they were compelled to by law. But I think they should take 130, 150 cases a year.
Yeah, the amount of cases they're taking over time has gone down.
Yeah.
And here's the thing: even if you made it like 100 judges right now in the Supreme Court, that's not going to change anything unless you have multiple Supreme Courts running at the same time. Because if all 100 have to hear something, they're only going to be able to hear the same amount of cases. So you would literally need multiple Supreme Courts, and that would be, insanity at that point. And then you need a Supreme Court over that court to break ties, if they start all breaking up on that. So it won't make it any easier. It won't make it any easier. So, yeah, more justices might actually slow the court down to an extent. I think you could probably get away with adding a couple more, but yeah, if there were 20, that would be a disaster. The Mad Hunt says, Private Clyde reporting for duty. Well, he's already here. Oh, wait, I thought he was still next to me. Never mind. JDK says they got quartered on your dime. Get it? Yes. And then Senor El Robato says, I guess it cannot always be en banc. Well, that would be the issue. Then how do you decide what becomes en banc?
Yeah.
And once again, it becomes the issue of, well, how do you have little Supreme Courts handling the cases, but let's say they start disagreeing with each other. Then you're back to like circuit courts again. So, and then you end up like India where the Supreme Court's like 100 judges or something like that. I forget, but it's like a disaster zone. DeFerris said, removing judges' feet off the court? No. At this point, I mean, I think 9 is like a good number. Like there's a spot where like if you start like this is the point where taking too many away, you'll kill its ability to do things fast, and if you have too many, it won't be fast either. I think we're kind of in a sweet spot.
Yeah.
So T-Rex Travel says, I'm still eating from your stream sweeping for KBJ. I know. She's our Numidian queen, chat. Our brave Numidian legal scholar. Kill Billy says, why not do a 3-panel review with the Chief Justice signing cases? Well, like I said, they might agree differently. So, the other group might want to hear a case. And if a similar case comes up at some point, are they bound by what some other justice did if they didn't get to have a say in the last case? And let's say panel 1 says X and panel 2 says Y. Well, who controls? I mean, because these cases do collide every once in a while. Roe versus Wade ended up having an issue. Chevron had an issue. I mean, that becomes a problem. That becomes a problem, in my opinion. I assume you similarly would say that too, Kurt. Right? Like, what do you do?
Yeah, and also that said the Constitution says there shall be one Supreme Court. So another
Yeah.
problem is if you do that, do we still have one Supreme Court? I'm not so sure we do anymore.
Yeah. Yes. Supreme Court A. It's like Supreme Court in lowercase letters. The more judges there are, the harder it would be to pay them off. You only have to bribe more of them. Well, okay, yeah, there's anything. And then Moments of Trading says it's Dolly Talk's birthday today. Really? Oh, well, awesome. Uh-oh, Clyde's in trouble. I better go get him in a second here. Do you think, Swissgar says, do you think Clarence Thomas living in VA will help the chances of 2A bans getting looked at? I'm sure he's already supporting those every time they come up. It's getting, probably Alito all the time. So you got two of them. And then it becomes an issue of getting like Gorsuch and Kavanaugh.
At least they took a couple this term. Like, it's actually taking some. So I'll take what I can get these days.
But there was a bunch of them they denied, though, that were pretty good.
So. Yeah, they really should take like 4 or 5 good ones every year. They did this with the First Amendment. See, when they discovered the First Amendment existed sometime circa 1939-ish, when they decided the First Amendment started to exist, they've been taking like 2, 3, 4 First Amendment cases every year. That's why we have such a nice body of cases. They just need to do that with the Second Amendment.
Well, it's like
then
the
we'll have
rights.
answers.
Yeah, it's like the civil rights case. It took a long time to get to where we were saying you can't treat black people differently. Nobody knows. It says, Kurt, would you have sex with KBJ if it meant you could take her place on the bench?
It's a sacrifice for this country.
Would you? I was going to ask. How'd your pound cake turn out?
Turned out pretty decent. I could have used a little bit more lemon flavor.
Would you share it with her?
Sure. If it meant getting her job, yeah, she can have a piece of my lemon pound cake.
Copia says it should have taken longer. Thanks, meme. Coming from the most ethnocentric nation in the ethnically homogenous nation in the world. Only with the Baldo. Well, there are not too many of those floating around anymore. So, all right, Kurt. Well, I think that's it. I think, like I said, I bet we're probably going to get a 6-3 on this because I think even ACB was like, even Comey was like, yeah, we're not doing this.
Yeah,
so
could be.
We'll see.
All right. Well, thanks for letting me drop by and hang with you for a while.
Of course. And guys, find Kurt over at Uncivil Law. What are you doing this week? Anything good?
I don't know if I have any particular plans this way. I just kind of do things as they come up. So we'll see what the content machine has and what looks good.
All right. Well, guys, thanks, Kurt. See you around, man. Have a nice night.
All right, bye-bye.
T-Rex Travel says, to quote the Queen, how dark do you think the babies would be, Kurt? Oh, God. Thumb Ugly says, uncivil, yes. GG, guys. I know, GG. The justices are cowards. They don't want to decide anything controversial. That's true. And you wouldn't think that, but as Matthew Harden says it, and I agree, John Roberts' desire is to be well-liked and invited to all of the cocktail parties up in Silver Springs and Chevy Chase, Maryland. He wants to be well-liked. That's part of his issue is he's got one eye on the history books and one eye on the public poll and not necessarily an eye on the court and the Constitution. Are there any updates on Iran? Not yet. Nothing big. Apparently, they're now asking to negotiate with J.D. Vance, which is impressive because before they were like, we're not going to do that. But I guess we vaporized enough of them and they're like, please don't kill us. Chevy Chase is an asshole. Not that Chevy Chase, Maryland. It's like a suburb like Bethesda. So the 82nd is getting mobilized. It is, but who knows what they're actually going to do. We'll find out. Chevy never donated to DSP. Well, yeah, that's assholes. Game recognizes game, chat. All right. Well, guys, give me about 10 minutes here. We'll start up a call-in show. I know you guys like that before we did the members only. We're going to do a call-in show for everyone, though. I don't know how that's going to go, but we're going to try it. So, which version of JD? The Overlord, the mnemonic baby entity? I'm not sure. Yes, Marlene is correct. Yes, tomorrow morning, check in with the council on future conflicts with Scott, Watcher, Joe Dolio, Very Old, Stan, Peter Rangel, the whole gang out there. Don the pleb, doing all kinds of awesome work out there. You guys can find them. They will do some good stuff, give you some good information to wrap your head around. And hold on here, chat. I'm going to... And yes, the call-in show is going to be open to everybody. So please don't be completely like... You know, chat, like the one thing I can trust you guys is you guys will not abuse the system. So I can't believe I said that with a straight face. Oh, I can't believe I said that with a straight face. But we'll try it and see what happens, because I am not so sure. Not so sure, but you know, like I said, we shall see, chat. We shall see. So with that said, chat, please remember, until next time, just because you did it does not mean you're guilty. Although if you're guilty of coming up to the border and seeking asylum, you know, I got to figure out how to say that in Spanish. Erica, you need to help me with that, because I need to do that, because I think that'd be so funny. So good night, chat, and I will see you guys in about 10 minutes. Take care. Let's see here. Hold on, chat. There we go. All right. That all worked. My unbombed seek asylum. Wait, so I get to say Baba Booey? Sure, if you want to. You can go like Baba Booey, Howard Stern's penis, and hang up. You could totally do that. You can totally do that if you want to. So, good night, chat. I'll see you guys in a couple of minutes.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy Rick Hayden yelled at? Why, yes it was.